In the
Go ahead,
last
ma'am. We are
module of
listening.
L2 Pro, we learned how to deal with IP disputes. Let's take a quick look at everything we learned. IP rights give you a bundle of rights to exclude and transact your IP. For example, to exclude others from making, using, selling, importing, offering for sale, or distribution. IP rights would be of little value if you did not have the right to enforce them. Even though many IP disputes are settled out of court, it is crucial to know how to deal with them to gather the full benefits of owning IP. One important fact to remember is that IP rights are private rights. That is why, when we talk about enforcement, it is businesses who should be interested in enforcing their IP. Since dealing with IP disputes needs specialized legal training and strategy, it is necessary to use the services of lawyers. At the same time, we need to understand the basics of IP enforcement. IP disputes can arise in the context of validity, infringement, and licensing. Validity disputes typically deal with the question of your IP fulfilling the minimum requirements of protection. They may also arise because of disputes on the subject matter. Sometimes, the other party may agree that your IP is valid, but disagree that they infringed it. In such cases, they might attempt to use the valid defenses available in IP law. Some valid arguments are research exemption, fair dealing, or limited, non-commercial use of trademarks. In case of licensing, disputes may arise at the early stages of negotiation, or sometimes even after negotiations have concluded. We learned that it is important to know the types of remedies you have if someone infringes on your IP. Civil remedies are available for infringement of all types of IP. They may take the form of injunctions, damages, or accounts for profit. Criminal remedies are available only in case of some IP rights, but not all. We learned in detail about all the types of civil and criminal remedies that are available to IP right holders. Next, we looked at the different factors you need to keep in mind when dealing with IP disputes. For example, market surveillance, demand notices, negotiating a license with the infringer, mediation and arbitration as an alternative to court proceedings, and out-of-court settlement of disputes. Lastly, we learned about border measures. In India, customs authorities can seize IP infringing goods. We have the IPR enforcement rules, which allow for enforcement of IP even before the goods enter India. We learned how these rules apply only to infringing imports and not infringing exports. But a civil remedy may be available in case of infringing exports. With this, we come to the end of our L2 Pro course. We hope you had fun learning about IP with us, and you will find it useful to apply it when required.
Namaskar and good evening to all. I would like to welcome you all today for L2 Pro workshop on resolving IP disputes for startups and MSMEs. Just want to make sure if
Yes, sir,
my screen is visible.
Yes, sir, it is visible.
Okay. Let's see. Okay, sorry about that. So I welcome you all for on the today for L2 Pro workshop on resolving IP disputes for startups and MSMEs. We want to talk about the power of arbitration and mediation. I'm your host, Nitin Sharma. I work for Qualcomm as Technology Counsel, looking for various IP initiatives at Qualcomm India. I also co-chair IPR committee at ASSOCHAM. This is a webinar series that we have started to connect with all of you in the field of intellectual property. As we all know, this is the century of intellectual property. For any country who aims to play a significant role in global economy, intellectual property is going to play a significant role or a crucial role in achieving that goal. Through this webinar series and the L2 Pro platform, our goal is to spread awareness around the IPR and IP strategy. Today's webinar is a very interesting one where we will hear insights around the resolving IP disputes for startups and MSMEs by using the power of arbitration and mediation from multiple distinguished speakers that we have today. We'll introduce them in a short while. But before we go to them and listen to their interesting insights, I would like to throw some light on the series. The series of webinars is brought to you by an IP course material called L2 Pro, which stands for Learn to Protect, Secure, and Maximize Your Innovations. Now, this initiative called L2 Pro, started with our is an output or outcome of our engagement with the government. As part of our Government of India's Make in India policy, we decided to basically come up with this platform to basically promote building effective IP strategy for startups, right? If you see the Startup India and Make in India policy of government, it puts a lot of emphasis on innovation and creation of intellectual property, right? So therefore, this platform and this initiative aligns with the government policies of Startup India and Make in India. Now, as part of our Make in India initiatives, we also have a program called Qualcomm Design India Challenge, wherein we invite a lot of startups to work with us and basically bring their innovations to the market. While working with them, we realized that while a lot of startups are well versed with the importance of IP and how to use effectively for their business, there are other startups who definitely needed a lot of handholding and guidance in that space. And therefore, we thought this kind of a platform would be a very helpful source or resource for them to understand and navigate through this through the IP strategy and make it useful for their startups. Now, this platform is basically accessible in two forms. The first one is l2proindia.com. It's a website which anyone can access, register, and then access. As I said, the goal of this platform is to increase awareness and improve the understanding around intellectual property, right? So it covers how to protect your innovations with patents, how to use copyrights to protect your, various, like protect your software and other, subject matter which is protected by copyrights, how to use trademarks effectively, develop it, etc., and how to basically integrate the IP decisions or considerations into your company's business model, right? As we know, IP is not a standalone concept. It has to be aligned with your business and business strategy, and therefore, this platform helps you understand how you could basically integrate it, right? Also, a lot of these startups or academic institutes who basically are into research and development, this course can help you understand how do you maximize the value that gets generated out of your research through protecting your innovation and using that as a tool for collaboration and for various other goals. Right? There are 3 modules in this platform. The first one is the basic module, which gives you an understanding of fundamentals around patents, trademarks, geographical indications, etc. The next level, which is the intermediate level, talks about NDAs, like when you engage with third party, how do you effectively use NDAs and ensure that your confidential information is protected? A bit more information about filing and acquisition of IP, how do you commercialize it, and so on and so forth. Last level, which is the advanced level, talks about funding and venture capital access, and it also talks about how the standards are being set and a bit of details around standard setting organizations. And finally, it also gives an insight into how do you manage disputes with respect to, if somebody's infringing it, how do you analyze the infringement, how do you analyze the validity, and what kind of defenses are available, right? And so in today's webinar, we'll talk about one of the concepts with respect to ADR, which is alternate dispute resolution from the experts that we have. This course also comes in the form of a mobile app. So there are some screenshots here that gives you an indication of how this looks like and how does it work. This also comes with some introductory videos which you can watch before you get into the topic. And then it also has a set of questions that gets popped up to understand your learning of the concepts that was just discussed. And so it's a kind of interactive one. And lastly, it gives you a certificate, which is co-signed by CPAM, DPIIT, NLU Delhi, and Qualcomm, right? So I think this is a very important certificate that you get out after completing this course. Now, with that, I would like to introduce our first distinguished speaker, Mr. A.J. Jawad. Mr. Jawad is a seasoned advocate with 35 years of experience in the legal field and a distinguished senior mediator and trainer with over 18 years of expertise in civil, commercial, international, and matrimonial mediations. As a senior mediator trainer with the Mediation and Counsel Project Committee of the Supreme Court of India and the Tamil Nadu Mediation and Conciliation Center at the High Court of Madras, Mr. Jawad has developed and delivered mediation training programs and trained the trainer programs, ensuring high quality mediation trainings with these organizations. His work includes conducting workshops on mediation in the National Judicial Academy at Bhopal and various other forums. He is also empaneled mediator with the Bombay Chamber of Commerce. He has extensive experience in cross-border mediations, resolving complex international disputes. He has served as a global faculty for ADR, ODR International, UK, and a lot more things, right? I can go on, but Mr. Jawad, it's really an honor and privilege to have you today. So would love to hear your thoughts. Over to you.
Thank you very much, Nitin. It's my honor and privilege to be here to talk about, of course, my favorite subject, because being essentially a lawyer, dispute resolution has always been something that I've been working on. And it has always been adversarial dispute resolution. So whenever the dispute arises, there was a time when the only option that we had was to go to the court. Or if there is an arbitration clause, we invoke the arbitration clause.
Right.
But the realization dawned on us that this may not be the best way of doing things. Perhaps there are better ways of doing things. So why should we always, because basically adversarial litigation is like those medieval days when you had a dispute, you invited your opponent to a duel. So you go into a park somewhere or a central place in the town, and then you have a duel there. You draw out your swords and you fight, and then whoever wins, whether he's right or wrong, stands vindicated. So that is how litigation itself works. So after 36 years of being a lawyer, I have completed 36 years now, but when I was in my perhaps 24th or 25th year, I was really thinking, am I doing the right thing? I mean, what am I doing here? Because what I realized was that there was no satisfaction on the side of my clients, even if we succeeded in the case, because they set out with some objective. They had a goal. They wanted to achieve something. But ultimately, what they achieved was not what, even though they succeeded technically, but it was not what they really wanted. So that was something that was always worrying me. So when I discovered mediation in 2006, it was a kind of a eureka moment for me. And I realized that, okay, this is what has been missing here. So now if you want to break down what is mediation, I mean, why mediation? What is mediation? Basically, when we have a problem with each other, we negotiate with each other, right? So when we have a dispute or when we have a problem, we sit and talk. I think that is the most civilized way of resolving a dispute, by sitting and talking to each other. And, especially in the context of the war clouds that are gathering over the country today, this is something that you really feel there is an urgent need to sit and talk across the table to find out some solutions, which would, prevent the loss of lives and the kind of economic hardship that would come up. So you negotiate. Now, what happens is when you sit and directly negotiate with each other, because you are in conflict, you have a dispute and you have a problem. So you're not able to see each other's point of view. Okay, you have your point of view and the other person has his or her point of view. And basically, you're not able to align with each other's perspectives. So you need a third person who will sit there and you say that, okay, this third person will facilitate the negotiation between us. So to describe mediation in a very simple way, it is nothing but facilitated negotiation. So the mediator, unlike a judge or an arbitrator, does not have the authority to impose any decision on the parties in dispute. The mediator cannot tell the parties that, hey, look, why don't you, settle it this way, or why don't you do it this way, or give a direction to the parties saying that this is what you should be doing. So this is the difference between a facilitated negotiation process. Another way of looking at mediation is also collaborative problem solving. Because what has happened all along is we have been looking at disputes as justice from a justice delivery perspective, where we feel that the person who is aggrieved by perhaps a breach of contract or any other issue that may have come up between two people, the aggrieved person needs to be given justice. Now, that perspective has actually led us to a very adversarial form of dispute resolution, where we necessarily have to, if I have to go to court, for example, against you, Nitin, I don't want to fight you, but I'm just giving an example. Okay, we are good friends. So basically, if you and I have a dispute, God forbid, now what I would do is I would feel that, if I have to go to the court or if I have to go for an adversarial process, even arbitration, for instance, I have to necessarily paint you black. I have to say all the bad things that you have done and portray you in such a way that you appear to be, the worst kind of person that ever existed on planet Earth. And I have to prove that also. And if I'm not able to prove that, and if you're able to prove that I'm the bad guy, then you win the case. So necessarily law forces you to become adversarial when you go for a litigation process. Now, there is a paradigm shift today in looking at dispute resolution, because from a fault finding paradigm, we are shifting now into a problem solving paradigm. So we realize now that, okay, you and I have a dispute. It is a problem. And maybe it is because of our differing perceptions or because of the way we have gone about the whole thing and the way we understand the terms between us. Perhaps that is the reason why we have this issue. And therefore, let's sit together and try to solve the problem. So that is the paradigm shift that is in the way we perceive dispute resolution today. And that is where mediation comes in as a very effective method. Now, the advantage of mediation is, one, it is voluntary process. Like if both of you agree, then alone you go for mediation. And it also gives you the flexibility to walk out of the process at any time if it doesn't suit you or if you feel that it is not serving your purpose. Okay. The second very important thing about mediation is it's a completely confidential process. So whatever happens in the mediation room between the parties and the mediator or between the parties inter se, it remains within the room. And only the agreement that you are able to reach at the end of the whole process is what actually, if it needs to be published, then only it gets published. Otherwise, everything is confidential. So like when I'm sitting for a mediation, I tell the parties that, that saying that, what happens in Vegas stays in Vegas. So what happens in this room stays in this room. Nothing can go up. So that confidentiality is actually a protective mechanism for the parties, because in the mediation process, you may be discussing a lot of things, okay, and you may be making a lot of admissions, you may be discussing proposals. Now, supposing the mediation fails, the other party should not hold that against you and say that this is what you said in the mediation, and therefore you're bound by it. So it is a without prejudice process, it's a confidential process. The third thing about it is the flexibility. Because if you go to a court of law or if you go for an arbitration, now I'll be coming to arbitration because that is also an alternative that we need to discuss. And perhaps the others will be talking more about that. But my focus today is on how we can use the tool called mediation in resolving even our IP disputes. Okay, so what happens? It's very flexible. Just to give you an example, when the mediation movement started in India, we had one of the first mediation centers was established in the Madras High Court. So in 2005. Now, one of the first disputes that came up was from a very reputed manufacturer of jeans. Okay, so a very famous brand of jeans. They filed a case against a manufacturing unit that was manufacturing jeans in Tirupur. And they were passing it off as that particular brand. Okay, so that they filed, for infringement, passing, vagera, all those grounds were raised, and that was referred to mediation. And what happened in the mediation was that the brand, the brand found out that this manufacturer, this guy who was running the manufacturing unit, was the jeans that he was manufacturing were of a much better quality than the regular supply that they had. So they entered into an agreement with this person saying that we will outsource the manufacturing to you. So you manufacture and supply to us. But don't, you don't put the label, we put the label, because that's our label. You have no right to do that. So a completely, out of the box solution, and it actually created an opportunity for both parties to, continue with the business. So there are, that's the flexibility part of it. Okay. And most important is the control remains in your hands. It doesn't pass off. Because if you go for a litigation or even for an arbitration, because both are adversarial processes, the moment you walk into the lawyer's office, the control goes out of your hand. Because it has to go according to the law. It is bound by the contract, and there's no flexibility there. And whether a judge or an arbitrator is bound by the law as well as by the terms of the contract, and also by the pleadings that you put before the court. So this becomes a sort of a very restrictive, problem, which stops you from or prevents you from coming up with solutions that may be workable, that might be flexible, that might be creative, that might be very innovative. So mediation offers you that possibility. So, these are just some of the advantages. And of course, not to talk about the cost factor, because cost factor definitely, even if you pay a good fee, a handsome fee to the mediator, you'll be spending still a far lesser amount and then what you would be doing in a litigation or in an arbitration. It would be much lesser than that. So these are the advantages of mediation. Okay. Now, what happens in IP disputes? Now, what are the kind of disputes that you come up with? And you people know much better than me about what kind of disputes that come up. The few disputes that I can think of is patent licensing and infringement disputes. That would be one area. Technology transfer and research and development agreements, software development disputes, trademark and design rights conflicts, franchising and distribution agreements, copyright disputes, digital content, entertainment, etc., and domain name issues. Now, all these are amenable to a negotiated resolution. And that is where you can effectively use mediation as one of the tools for doing that. Now, there is also a history of this. It is possible. There are many disputes that, very famous disputes that have got some international, that have come to the notice of the world. These disputes have also been resolved. For example, Nokia versus Daimler. That was one dispute that was referred to mediation. And what actually happened was the mediation failed. They came back to the court. But at one point of time, again, they went back and they had a settlement. So that was one dispute where it was also a multi-party dispute that got resolved. Apple versus HTC. This was another dispute, which was a smartphone patent conflict dispute that was resolved through mediation. Now, there are many disputes which, Asian medical device companies that get involved in all kinds of patent and, confidentiality disputes. So even here, mediation has proved to be very effective. And we all, I'm sure we all know of this organization called WIPO, World Intellectual Property Organization. It has got a very robust mediation and arbitration center. So this mediation is the, the port of first call that usually parties resort to when they go take their dispute before WIPO. And there are many examples of these disputes, between Singapore and Malaysian companies. There was some trademark opposition that was resolved Bayer crop science, that was another international patent disputes. So these are all disputes that have been resolved, and WIPO has got its own rules. Now, what we are trying to do here in India is that we are trying to promote what is called as the med-arb model. Okay, so we go for mediation first. We try to resolve the dispute through mediation, and if that does not work, then we go for arbitration. So there are two concepts that I would like to place here in this webinar for the consideration of all those who are attending this, because what happens here is that we are trying to, through the International Arbitration and Mediation Center, we are training people who specialize in IP disputes, okay, so that they can be mediators, and we are also creating a panel of arbitrators. So we are having different verticals where for different kinds of disputes. Even insolvency professionals we are training. So similarly, we are trying to train the IP experts who can become mediators in these disputes and offer their expert help. So what happens is we have very clear rules. So what companies need to do is they need to include a med-arb clause in their contract. Now, if you go to our website, you will find the mediation clause as well as the arbitration clause. So what we are contemplating here is a hybrid process, where you are assured that once you have a dispute that gets resolved, either through a collaborative process of mediation or through the process of adjudication, if that does not work out. So both the alternatives are available for you. Now, one of the biggest challenges in only having an arbitration clause is that without naming an institution there. If you don't name an institution, what happens is, so when a dispute arises and you invoke the arbitration clause, you invariably send a notice to the other side saying, please accept the invocation of the arbitration, and please accept my nomination, the person nominated by me as the arbitrator. Now, most likely the other person is going to say, sorry, I'm not accepting. And then you're forced to go to the court. You're forced to file a Section 11 application, wait for the court to appoint an arbitrator, and then the arbitration process starts. But when you go for institutional arbitration, if your clause says that if I have a dispute, I'm going to approach an institution like the IAMC. Now, what happens is the moment the dispute arises, you approach us, and we appoint the mediator first. And we give a time frame for the mediator to resolve the dispute. And if that does not get resolved, we immediately conclude the mediation and appoint another person as an arbitrator. Now, it depends on your agreement whether you want a sole arbitrator or 3 arbitrators. So you're given the opportunity of choosing the mediator as well as choosing the arbitrator. In case you're not able to decide, we step in and we appoint. So now what happens is, it becomes a seamless process where you don't really have to waste a lot of time. Just give me 1 minute. Just give me 1 minute. I'm sorry. So when we have the specific clauses which name an institution, now the advantage that you get from that is that even if both parties are not able to agree on the appointment of a mediator or arbitrator, you don't have to go to the court and wait for the court to appoint an arbitrator. So the institution appoints the mediator, the mediation process goes on, and in most of the cases, parties realize that, what are the consequences if they don't resolve, and what do they have to face, and what are the kind of costs they're going to incur. And invariably, there is a resolution that happens. And that could be a very creative resolution because you have experts assisting you in trying to negotiate and come to an agreement. Now, once you reach an agreement, then that becomes, right now we have a Mediation Act of 2023. Now, unfortunately, the Mediation Act has not yet been notified. The moment it gets notified, what will happen is the mediated settlement agreement has the effect of a decree of the court. So in case any party commits a breach, because that's a very important question that people have in their mind. Okay, I'm reaching an agreement. Now, what happens if somebody breaches that agreement? Do I have to go back to the court and file a fresh proceeding against that party? The answer is no. Once the Mediation Act comes into force, you don't have to do that because you can straight away go and execute that agreement. You can ask the court to enforce that agreement. So that is the advantage that you get. Now, in the absence of the notification of the Act, we fall back upon the Arbitration and Conciliation Act, because Part 3 of the Arbitration and Conciliation Act talks about conciliation. Conciliation is nothing but, again, a process that is very similar to mediation or almost identical to mediation. It is confidential, it is voluntary, and it also is something that facilitates the parties to reach an agreement. The only thing is, under the Act, the conciliator can go one step further and suggest the terms of settlement to the parties. So that added advantage is there for a conciliator. But in the case of a mediator, the mediator is purely facilitative and tries to bring the parties to an agreement based upon what exactly their concerns are, what their underlying interests and needs are. Based upon that, the parties are assisted in reaching an agreement. So right now what we are doing is we are treating it as a conciliation, because what happens when you reach an agreement through a conciliation process, it is deemed to be an arbitral award on agreed terms. So it's as if an arbitrator has passed an award. So it's like more or less like a compromise decree. And if any party breaches the terms of that settlement agreement, you can always go to the court and execute that straight away, enforce that straight away, without the process of going through filing a suit and then going through the whole process. So this is these are the advantages that you have. So coming to arbitration itself, institutional arbitration, as I pointed out, is always a much better option. Now, this is something that just a few days back, there was a conference that was organized by the Attorney General of India, where the Mediation Association of India was formed. And even here, while discussing this, I pointed out the advantages of institutionalizing the mediation and arbitration process, having institutions like the IMC in every state in India. So these are the advantages that you have if you institutionalize it, because the process is much faster. And I'm sure Adarsh will agree with me, one of the biggest challenges in arbitration is that once you go and file under Section 11, you may not get an expert as an arbitrator, but you may get somebody else. Now, there is no control after that over the cost of the arbitration also. It can be phenomenal, and there's no control over how the process continues. Though arbitration is all about party autonomy, it's about giving parties the right to choose their own forum. But then that is taken away in a different way. So that is, to avoid that, the best way is to go through the institutional route so that you retain the control. Okay. Now, the other thing that I wanted to point out was that one of the biggest challenges in business today is when we are entering into the agreements, when we are signing the deals. Now, here what happens is it's like a marriage. Okay, so when you're getting married, you expect everything to be hunky-dory. You feel that everything is going very smoothly, and you don't have any. There's no businessman ever anticipates, like no bride or bridegroom ever anticipates getting divorced. Similarly, no business person who is entering into a deal anticipates any problems that are going to come up. So what we are offering today is also what is called as deal mediation. And this is particularly important for startups because, in order to have a fair deal, because what happens when you're negotiating a contract, both sides are represented by their lawyers, and the lawyers are looking at it only from the perspective of protecting their client's interest. Now, depending on how powerful your position is or how strong you are at the negotiating table, you may get a deal that is much beneficial to you, but not as beneficial to the other party. And as the transaction is working out, it may run into trouble, and it may end up in a dispute coming up, and that leads to the whole the contract coming to a standstill. Now, in order to avoid that, deal mediation is one concept that we are trying to promote very aggressively in the IAMC. We are saying that before you enter into the contract, both sides agree to appoint a mediator. Now, this mediator will help you to negotiate terms that are fair and reasonable to each other, that would help you to reach a good deal, that would be balanced, that would be fair, that would give both parties an opportunity to execute the contract without running into any kind of problems or, trying to. So basically what we are talking about is dispute preemption rather than dispute resolution. So when you preempt the dispute, you stand a much better chance of, seeing the contract through rather than ending up in a dispute and then going for the dispute resolution mechanisms. Now, in spite of that, if the dispute runs into trouble, you always have the institutional route, because if your clause talks about mediation, and then arbitration. Now, as far as mediation is concerned, there is still a little gray area there that if you have a clause that, where you agree that you will go for mediation and then you withdraw from that, or you don't submit yourself to the mediation, whether that can be enforced or not. Now, there is still a gray area, but, in Western countries like in UK and all that, there is the concept of mandatory mediation that is being pushed. And we are also trying to do that in India because you have already given your consent when you signed the contract. So therefore, the question of withdrawing from that does not arise once the dispute arises. So it is in the interest of both parties to go for the mediation. And if in case the mediation fails. Now, there are many cases where, I have come across where whenever I have mediated, I found that there may be very simple issues that may be at stake. And unfortunately, what happens is when you adopt the adversarial approach, it becomes very complicated. So what is very important here to bear in mind is, what are the advantages of mediation? I'll quickly just, take you through that and just stop there, okay? Confidentiality is crucial because, in any IP dispute, there is very sensitive proprietary information or trade secrets that are often at stake. Now, mediation ensures that all this information remains confidential, unlike court proceedings, which are usually public. Preserving the business relationship, because usually IP disputes arise between parties who have or may want to maintain an ongoing business relationship, licensors, licensees, for example. So mediation fosters cooperation and helps preserve or even strengthen these relationships. The fourth thing is courts are limited to legal remedies, as I said earlier, whereas mediation allows for the creative and commercial solutions, cross-licensing, future royalties, joint ventures, all these possibilities are there. And also the global nature of IP disputes, because often, most IP disputes involve parties from different jurisdictions. So mediation can accommodate the cross-border disputes without being bogged down by conflict of law issues. So there is every possibility that you may reach an agreement that would be, acceptable to both parties without necessarily worrying about the conflict of laws. So that is one advantage. Now, the only drawback here that I see is India has still not ratified the Singapore Convention, though India was one of the first parties to, sign the Singapore Convention in 2019. Now, mediation also, complements the formal IP systems because it can be integrated into enforcement strategies and can complement the, patent or trademark office proceedings. WIPO offers this actually. The most important thing is cost and time efficiency, particularly valuable for startups, small businesses, and individual creators who cannot, afford lengthy litigation. And you can get expert mediators with IP or technology backgrounds. They add a tremendous value by understanding the nuances and the stakes involved. So with this, I'll just stop here, and I would love to hear what Adarsh has to say, and then perhaps we can discuss. I hope I did not exceed my time.
Thank you, Mr. Jawad. I think wonderful, and thanks a lot for giving a very comprehensive overview of what it takes to get, dispute resolved through ADR mechanism and MedArb, etc. So,
Thank you.
Again, wonderful insights. So our second distinguished speaker is Mr. Adarsh Ramanujan. Adarsh Ramanujan is an independent litigation attorney with a counsel practice. He has represented clientele in a wide range of sectors, and he has been involved in handling disputes in diverse areas of laws, including IP litigations, commercial arbitrations, competition law, contractual disputes, international disputes, debt recovery, and SORFISI matters, biodiversity laws, right? He draws from his considerable exposure on experience in international disputes and a 3-year stint in Geneva, Switzerland. In his current and previous roles, he has appeared before arbitral tribunals as well as a variety of domestic and international forums, including Supreme Court of India, various high courts, tribunals, the WTO and the EU Commission, US Department of Commerce, and the US International Trade Commission. He is one of the youngest persons to have represented a sovereign government as lead counsel before the WTO. Mr. Adarsh, it's an honor and privilege to welcome you. over to you for your thoughts on this topic.
Thank you for the introduction. I hope I'm audible.
Yes, please.
Thank you for the introduction, and it's my pleasure to share this 1 hour of time with all of you and the participants. And I'm grateful for the opportunity. This is an interesting topic because I started my career as somebody who did not like mediation and arbitration. My life as a lawyer started as a disputes lawyer, and even today, most of my time is spent in court litigation. Nevertheless, over a period of time, I've slowly evolved to participate in arbitral processes, both as a counsel for parties as well as an arbitrator. And my over time, I have therefore started liking arbitration as an alternative dispute resolution process. But my uptake to mediation was a little slower than that. Mediation is something I still have my doubts as an effective resolution, specifically in IP disputes. But there are, I believe, a certain class of IP disputes where mediation makes a lot of sense. So I intend to share a little bit of my practical experience in this area of IP disputes in particular, because that's what we are focusing on, and to what extent arbitration and mediation are increasing playing roles and what challenges we continue facing in both these areas. That's what I intend to cover. I'm going to pick up from where my friend has left and start with mediation as an area. Now, if you look at the general statistics, if you ignore IP as a subject and you look at the general statistics, now the National Legal Services Authority indicates that if you take the last 10-year period up to 2022, etc., over 0.11 million disputes have been settled through mediation. And if you consider the statistics published by the Delhi High Court Mediation Center, Arbitration Mediation Center, between 2006 and 2024, so you're talking about a roughly 20-year period, maybe 18 years to be specific, of the 39,000 cases that have been, roughly 39,000 cases that have been referred to mediation, on an average, on a rough estimate, it's all the statistics are available on the website of the Delhi High Court Mediation Center if for those who are interested. But the indication is about 40 to 45% are successfully settled. If you take IP specifically, according to the Delhi High Court IP Division Annual Report of 22-23, the indication seems to be that about 80% of the IP disputes referred to mediation under the aegis of the Intellectual Property Division of the Delhi High Court have reached settlement. So if you focus on that number for a minute, that's quite a high number. I will also put the other perspective, and this is something that our friend Jawad just mentioned also. There are two types of mediation. One is voluntary and one is mandatory. In India, the mandatory aspect of mediation was incorporated in the Commercial Courts Act in 2015. And in 2015, it was mandated that for any commercial dispute, and IP disputes fall within the bucket of a commercial dispute, the plaintiff must mandatorily seek a pre-institution mediation or pre-litigation mediation before going to court. The only exception to that rule was if the plaintiff is contemplating urgent interim relief, such as an interim injunction or the appointment of a court receiver or court officer to seize infringing material and so on. That's the only exception in which this pre-institution mediation can be exempted. There is a whole line of jurisprudence on when this exemption can be allowed or not allowed. I'm parking that aside for a minute, but just focusing on the success rate. Here you will see a slightly interesting phenomena, which is according to the statistics, in cases where there has been such pre-institution mediation, of a total of cases that have gone to this pre-institution mediation, the indication is roughly only 25% have met with some success in terms of resolving the dispute before going to court. In a large majority of cases, it is a non-starter, which is to say the other side has not even come to the table to discuss, or the parties are not able to reach a actual settlement. That's about 60 to 70% of the cases. Which means if you focus on this idea of a mandatory mediation, which is coming under the aegis of the Commercial Codes Act, it's largely not been a very successful model, at least statistically speaking. And the statistics that I'm representing as far as the mandatory mediation before litigation, that's only giving you a half picture, and even that picture is negative, as I pointed out. The full picture comes when we focus on that exception created in the law, which is the ability of a party to say that I don't need to do this mediation before litigation because I'm seeking urgent interim relief, so I have an exception in law. There has been some concern on what is the test to be applied by the court to determine when this urgent relief is there, or when the urgent relief is just a guise or a false narrative to skip the mediation and directly go to court. So Supreme Court has held that as much as it's a mandatory requirement, the court will examine or has the power to examine if the party coming to court without mediating first is doing so as a camouflage, is doing so by building a false narrative, by creating a deception as if there is a need for an urgent relief, whereas in reality there is no need for an urgent relief. This is the test that the Supreme Court has laid down. But the fact of the matter, when you look at actual IP disputes and actual litigation that takes place before the courts, 100% of the IP disputes, rather 90 to 95% rather, of IP disputes, the party seeking to enforce the IP is always asking for the exception, because every IP case mostly comes with the request that the mandatory mediation be exempted for them, since there is a need for an urgent interim relief in that case. The issue that arises is the Parliament enacted this mandatory mediation for one reason, which is that the backlog in courts is too high. The court is not able to handle the amount of cases that it's facing. So we need to rethink and think out of the box. So first, the Supreme Court therefore holds in Patel Engineering that this pre-institution mediation is absolutely mandatory and must be complied with. Thereafter, when the issue of exemption came, how do you interpret the exemption? The Supreme Court clarified in a judgment called Yamini Manohar that the only exception is if urgent relief is being sought. And at that point in time, the court has the power to examine if this urgent relief is being sought in a deceptive manner, only to circumvent the mediation process. But that application of that test in facts from case to case basis is very, very complicated, because a judge looking at the dispute on the first day of the case is unlikely to have a full picture of the case. And it's not humanly possible for any judge to get a full picture of the case on day one. So on day one, it's impossible for a judge to decide whether the narrative being given by the party is false, deceptive, camouflage, or it's a genuine case of urgent interim relief. So as a consequence of that, as a matter of default, in probably 90 or 95 to 99% of the cases where an IP holder is seeking that exemption from mandatory mediation, it will be granted by the court. And the number of cases in which this exemption is being denied by the court is far, far less. You can maybe count it in the finger of your hands. So my experience as far as pre-institution mediation, that is mandatory in nature, I would simply conclude, at least based on my limited experience, that it's a failure. Because in IP, I believe that most people who have come to court, they have more or less taken a view that they want to spend that money and they want to spend that time and effort in order to get an immediate relief. And they are not interested in spending time in mediation. This has been my observation largely as far as IP disputes are concerned in the form of mandatory pre-institution mediation, right? If you exclude that one bucket of mandatory pre-institution mediation and we look at the concept of voluntary mediation, under the Civil Procedure Code itself, the court or the judge who's hearing the matter has the power to refer the parties to mediation based on the circumstances of the case. And what I've generally observed in practice is that good judges have a very good instinct and sense of when the dispute is of such a nature that can be settled by mediation. And classic examples where IP disputes are far more likely to get settled in mediation rather than litigation, I would broadly put it in two heads. One are disputes involving family members. I'm sure many of you have heard of these disputes from newspapers. There have been several recent instances. You have the Hero Group, you had the Lodha Builders Group. These are two common examples. There's the Haldiram Group dispute still going on. In cases falling in this bucket, where the disputing parties are family members who, at least currently are in dispute, but otherwise they have some connection, a familial bond amongst them, mediations are far more a better solution than litigation. And this is largely because of the point that Javed mentioned earlier, which is the idea of flexibility. Because the moment you're into the litigation process, and even for that matter, arbitration process, you've got a framework within which all the stakeholders must operate, whether it's your lawyers, it's the judge, or the parties themselves. There is a framework that you cannot exceed. And it's a rather strict framework. And disputes will have to be resolved based on the black letter of the law. Some wiggle room is there for a judge to look at our equity and justice, but beyond that it's a rather limited wiggle room, especially when there is a contract in place between family members. But in the case of a mediation, you have far more flexibility to step outside the terms of the agreement, to sometimes step outside the framework that the law prescribes to you. And you can have other considerations that come into play. And I have found in this bucket of cases that if you've got a good mediator with the ability to, make the parties see their respective positions more clearly, it's a far more effective solution than the long drawn battles in court, because they tend to get emotional. They tend to get, sidetracked by a number of non-legal considerations. So this is one bucket that I've seen that mediations work very well. The other bucket that I've seen mediations work very well is where the real fight between the parties is money to be paid under a license agreement or a potential license agreement. But the fight is only on this money. So say the party is enforcing, an IP against a defendant who was a licensee who has now violated the license agreement and therefore, is acting in infringement. Or he's violated the license agreement by not paying the money required under the license agreement, but otherwise continuing to use the IP. In these types of cases, or a third case to consider is standard essential patent disputes. That's been a recent phenomena that many of you would have read, which is when patents cover standards like your telecommunication technology in 2G, 2.5G, 3G, 4G, 5G. And because the defendant must comply with the standard and ergo automatically infringe the patent, in those cases, the real fight is money, because nobody is going to stop them from complying with the standard. And at the same time, the IP holder who has helped in developing that innovation is to be paid. So again, it's a question of the fight is on money. So there has been a series of Nokia cases and Ericsson cases which went into mediation in the Delhi High Court, standard essential patent cases, and successfully settled because the parties were able to hit a number that the defendant will pay to the plaintiff, and therefore there's a license agreement reached and the parties didn't litigate. That would have typically taken easily 10 years for the trial to get over and the parties to have finally seen the color of the money, or vice versa, invalidation of the patent. So this is the third bucket within the, or the third category within the second bucket, which is where money is the real core of the fight between the parties. There also I find that mediation is a very effective solution. But barring these kind of buckets, my experience with mediation has been that it's generally not helped parties reach a settlement in hardcore IP disputes where there's a fundamental dispute on who is owning the IP itself, or whether the defendant has a right also to parallelly use the IP. So this has been my experience as far as mediation is concerned. So it is both a positive and a negative depending on the bucket of cases that you're in. But my general conclusion at least is the idea of a mandatory mediation doesn't work because it is an anathema to the concept of a mediation which is supposed to be voluntary. And I feel that the failure of the mandatory mediation model is also psychological, by the mere fact that you are being told that you must mediate. It has to be a more consensual process. And I think you'll see that Mr. Jawad was mentioning about the Mediation Act, which is yet to be practically implemented. But if you see the history of the mediation bill, the original bill also imposed a mandatory mediation, which ultimately they amended and say, no, pre-litigation, you'll have to do voluntary mediation. So I believe there is a role for mediation in IP disputes, but only in certain cases. So it's very, very critical, therefore, for lawyers to be trained properly on instances where mediation is a real better course of action. So it is not just about enlightening the parties who are potential clients and disputing parties or litigants. It is critical to have lawyers, specifically in the IP field, also trained a little bit on mediation so that they're able to spot cases that are capable of being settled through mediation and perhaps advise litigants accordingly. So there is that role that I feel mediation continues to play and will continue to play in IP. One observation I've generally had, at least for mediation in IP at a practical level, is the necessity to have a panel of expert mediators who also understand IP. Because, for instance, in the Delhi High Court, at least, we have a large mediation, a panel of mediators, and a large amount of them have good expertise in IPR. And I believe that subject matter expertise makes a big difference in the success of the mediation also. So that's the other takeaway that I've had from my practical experience. I mean, with this, I will end my discussion as far as mediation is concerned. And second, we move to now arbitration. So in arbitration, I think my friend had very nicely put across the difference between mediation, conciliation, and arbitration. Mediation being the lowest threshold in the sense that the person appointed as a mediator, the role he plays is more in the nature of an invisible hand, lesser interference. It's just helping the parties reach a point of convergence. A conciliator has a slightly higher immersive role in bringing the parties to a settlement. And last and final in that spectrum is arbitration. In one sense, an arbitration is like a judicial proceeding because the end result of an arbitration is not an agreement between the parties, but it's what is called as the award. An award is like a judgment, which is final and binding on the parties concerned. It is not based on what the parties agree to, but it is based on what the arbitrator or the panel of arbitrator has adjudged or adjudicated. So it's in this side of the spectrum of ADR. I've had a lot more experience doing more arbitrations than mediations, at least in the IP context. What's the positive and the negative? Now that we've seen the arbitrator, and Mr. Jawad has already covered typically how the arbitrators are appointed. You'll have a single arbitrator or a panel of 3. You can appoint the arbitrator by consent, or you can go to court and they will appoint an arbitrator. So some positives that I've seen, I have been able to complete as a counsel, for example, a complete arbitration proceeding from beginning to end within 2.5 years, meaning from the start of the case to the final award, judgment, or decree, whatever term you want to use, which in a court litigation might have taken me at least 7 to 8 years, right? So the time period within which I'm able to complete or bring some, conclusion to the proceeding is much shorter in arbitration if you are able to push through and you have good arbitrators adjudicating the matter. This is one positive that I felt in arbitration. A second area where I feel arbitration is an excellent ADR for IP disputes is when you have multi-jurisdictional IP disputes. And multi-jurisdictional need not be just cross-country, where you've got disputes across multiple countries. But you can also have disputes across multiple states within the same country. For example, parties living in 2 different states, cause of action in a third state. I find arbitrations much more effective there also, because we take away unnecessary fights on jurisdiction. I think arbitrations make sense there also. But arbitrations come with their challenges. Over a period of time, litigating parties have kind of realized what I call as a trust deficit in the system of arbitration, because there are allegations of impropriety and so on in a number of ad hoc arbitrations, which is why there is now a slow direction and movement towards institutionalized arbitration. And I feel over a period of time in India, slowly and steadily, with good arbitrators being empaneled at various institutions, we will see the increase in institutionalized arbitrations over ad hoc arbitrations. In other jurisdictions of the world, institutional arbitrations is really the typical route. You take Singapore or London or the US, usually, or Dubai, for instance, all major arbitration centers. Most arbitrations take place through the aegis of an institution. What happens by that is that there is an institution like an arbitration center, which will have rules framed on the conduct of the arbitration proceedings, timeline fixed. They will have a panel of arbitrators to choose from, and they will regulate the overall procedure. In an ad hoc arbitration, you don't have such an institution. Everything is done by the arbitrator themselves. I feel that the shift has to go towards institutional arbitration, and that will strengthen arbitration procedures. So that one negative that I've seen in practice is this slowly evolving trust deficit in the arbitration procedure. Second, enforcement issues. So as many people will be aware, once you finish an arbitration procedure, the end of the proceeding is what is called as an award, like your judgment that you get from a judge. But it's ultimately just a piece of paper. You have to enforce the award. And there is a proceeding under the Arbitration Act, depending on whether it's a domestic or international arbitration. You will file an application for enforcement of the award, and the other side has the chance to challenge that award. The difference between a normal civil suit and an arbitration is the grounds on which the award can be challenged are much, much narrower in the case of a domestic arbitration, and even more narrow in the case of an international arbitration. But even this is subject to an appeal, which is in turn subject to the Supreme Court appeal in SLP, special leave petition. So there are cases where I've been able to complete the actual arbitration proceeding, which is trial, evidence, witness, cross-examination, everything, say within a span of 2.5 years. But after I finish that 2.5 years, and you have the loser in the arbitration, or the debtor, award debtor in the arbitration, who is refusing to comply with the award, so you've got to enforce it. And the other side therefore challenges the award in the court. That court proceeding, which is post the award, sometimes has spanned more than 5-6 years. So net what happens is, in situations where you have a non-cooperating party who will not comply with the award despite the award because they want to challenge it in court and so on, net the total amount of time taken in arbitration becomes equal to what you will have in a court proceeding. Of course, even in a court proceeding, after you succeed, you still have execution proceeding and so on, but it still takes a lot of time, even in arbitration, if the other party chooses to challenge. And that has, I think, created a lot of negative impression for litigating parties, because the reality is arbitrations have become much more expensive in India, because arbitrators also charge a lot. These good ones charge a hefty amount, and lawyers also charge much more in arbitration than in litigation, like in a court proceeding. So on the one hand, you're able to conclude the arbitration proceeding faster, and on the other hand, the enforcement takes much longer, and the total cost actually balloons for the party. I think this can only be addressed with some level of interference from the parliament also, and a little more caution in how awards are seen in courts during enforcement. Without getting into too much of a discussion, I think jurisprudence wise, as much as many people feel that the grounds to challenge an award are very narrow and limited and so on, the reality is that as lawyers, we tend to argue till the cows come home to challenge everything. Everything is argued as if it's being argued for the first time. So over time, we have also cultivated a system where award challenges have become as complicated as the arbitration itself. A lot of judges have commented on it. Very recently, there's a Supreme Court judgment that came 2 weeks back where such an observation was made that the whole thing was being argued as if it's being argued for the first time at the Supreme Court level, which is an enormous amount of enormous waste of time and energy. Which means we need to, as a system, to make arbitrations more effective, we need to have a better case management system when arbitration cases are being heard in court. And I believe, for example, that how Delhi, Bombay, Calcutta, and Chennai and have come up with IP divisions or intellectual property divisions in the High Court. It is absolutely essential that these courts also have an arbitration division where the courts are exclusively hearing only arbitration matters. And the final point on arbitration that I want to indicate is there is also some confusion on the arbitrability of IP disputes. In principle, at least there are two judgments, of one from Bombay High Court and Madras High Court, the other from Madras High Court, which clarify that IP infringement issues and IP licensing issues are arbitrable. You of course have the entire Supreme Court line of jurisprudence, with Vidya Drolia and so on, which clarify that in rem disputes or ergo omne disputes, where you're affecting the rights of parties at large, they are not arbitrable, but private rights are arbitrable. So which means, for instance, I as an IP holder, I enter into a license with you, and I find that you are acting in breach of the license agreement, or you as the licensee feel that I'm acting in breach of as the licensor of the license agreement, and there's an arbitration clause, that dispute, even though it's connected to IP, is totally arbitrable. And if I feel that you've violated the terms of that agreement, and therefore it's an act of infringement. Just because you call it infringement doesn't make it non-arbitrable. It's also an arbitrable case. The problem arises on the flip side of the coin. Because in most IP cases where one party is asserting an IP right against the other, the counterblast is always a challenge to the validity of the IPR. For instance, if a trademark is being enforced, you can file a rectification to challenge the trademark. If a patent is enforced, you can file a revocation against the patent. If a design right is being enforced, you can file a cancellation petition. The current thinking is any in rem proceeding or a proceeding that affects a right in rem is non-arbitrable, which means the implication is that the cancellation proceeding or the rectification or the revocation to challenge the validity, that cannot be arbitrated. But the enforcement of the IP is arbitrable. So you've got an imbalance here. And this is a very critical imbalance because if a plaintiff goes to court to enforce an IP, the defendant has the right to defend the case by challenging that IP. Then in one proceeding, the whole thing is closed. But if you go to arbitration, only one side of the case is arbitrable, what the plaintiff says. What the defendant says is not arbitrable, which means the defendant will have to go to other proceedings. So you split the proceeding. What could have been done in one forum in one court is now split across two forums and two courts, one arbitration and one court. In other jurisdictions, for example, whether it's US or the UK, even this validity part is arbitrable. Whereas in India, it is not, at least in the current state of the law. So that's another tricky point that comes when it comes to arbitrating IP disputes. But I feel that to the extent we are able to come up with better case management practices at the court level, how do you deal and what is the timeline to be specified? How do you, by when should you conclude a award, a challenge to the award in court? What extent should appeals be entertainable? Once we streamline the court process and enforcement of an award, I feel arbitrations are a better approach in some cases, if based on the complexity, because the arbitrators will have the time and energy to deal with it rather than in the court system. As I said, two caveats. One, we need to really streamline court procedures and formalities for award enforcement. And two, it's high time that we propagate and move towards institutionalized arbitrations and ad hoc arbitrations in India. I think with these two caveats, I would say arbitrations are an excellent route by which you get through this to resolve IP disputes. Because on the arbitrability issue, I believe more cases will come in the future and we will get some clarity, though I believe the parliament should take, now that the bill is in play, even in the Arbitration Act, they should make the effort to actually do an amendment to clarify this position in the new act itself. With that, I think I will bring my talk to a close and open it up for discussion. Thank you again.
Awesome. Thank you. I think this is wonderful insight into how the mediation and arbitration have played out in the IP space. So great summary. And some of that is reflected in the comments as well. So a lot of appreciation that's flowing in. So I think let's pick up some questions here. Of course,
I think before that, just on whatever others spoke, because I think more or less we are in tune with each other on whatever we have discussed so far. Just one or two things that I want to point out very briefly, as quickly as I can, if you permit me to.
absolutely, please go ahead.
Yeah, just one thing is that, mediation is possible in all those matters where you can negotiate and reach a resolution. Okay, let's be very clear on that. Okay, it's not something that where a particular issue needs an adjudication by the court, as others rightly pointed out. If it's a right in rem, for instance, and that requires a declaration from the court, that is not something that can be mediated. Now, one of the things that I would like to place here is that all our experience has been, because Adarsh very clearly said that, his experience with mediation has been with the court annexed mediation.
Right.
So this is one of the biggest challenges that we have today, because all our experience has been only with ad hoc mediations that are referred by the court. After the parties are there before the court, once the dispute has arisen and once they have gone in for litigation. So from there, for them to, come back to the negotiating table becomes very difficult, because there have been, a lot of allegations have been traded, and as others pointed out, emotions are very high. So, mediation always, before the litigation is taken recourse to, is the best place to begin with for mediation. And, one of the challenges, because we have this ad hoc mediation and ad hoc arbitration today instead of the institutional mediation and institutional arbitration, is that we don't have experts dealing with these matters, where these kind of matters, IP related matters, need some level of expertise, some level of knowledge on the part of the mediator as well as the arbitrator. So the problem with the ad hoc process is this. So the solution on moving forward would be, because in India, all along, we have been having only these ad hoc processes. And the institutionalization has not been aggressively promoted. I don't want to comment on that. I'm sure Adarsh knows what I'm talking about. Okay, so there is a vested interest in some sections here, which stops the institutionalization from, gaining momentum. The other thing that I really want to emphasize on, that others also pointed out, is the mediation advocacy. Because today, how are we training the lawyers? Because we are training lawyers only to look at the dispute from the fault-finding paradigm, not from the problem-solving paradigm. And this becomes a challenge when a lawyer is advising a party on what is the way forward. So is this something that should be negotiated and resolved, or is this something that needs to go to the court necessarily? Now, this becomes very important, because mediation advocacy training for lawyers is absolutely essential. Okay, so that is one thing. And basically what it requires is a mindset change, because we are so invested in the adversarial method of dispute resolution that we are not able to look at what promises the collaborative process holds. That is one. Okay, and he has rightly pointed out about the trust deficit in the ad hoc, and that's where, SIAC, for example, they scrutinize the awards to, just to make sure that these small errors that creep in and, which can be interpreted in different ways in the court, these are all avoided. Proper reasons are given for each finding. So that is something, that's an advantage that you have in institutional arbitration and mediation. Okay, and case management is another point, thing that I would like to really emphasize on, because institutional arbitration or mediation ensures that there is a proper case management process in place, which not only expedites the whole thing, okay, but it also, the whole thing is moving seamlessly. It is streamlined. And the most important thing is, in institutional arbitration or mediation, you can choose your experts. Okay, you don't have to necessarily rely upon some ad hoc decision taken by a judge in appointing somebody as an arbitrator. Okay, or you don't have to go before, because one of the biggest challenges of the Commercial Courts Act mediations being linked to the Legal Services Authority, because that's not the job of the Legal Services Authority. That's not the job of the Legal Services Authority is to to provide legal aid to those who can't afford. You can't expect them to have a panel of mediators, monitor how the mediators are functioning, ensuring that they get proper training. Now, these are the challenges, because the lack of proper training for mediators in the court annex program is another big challenge that we are facing today. So that is where I think I'm very glad that Adarsh agrees with this aspect also, because he focused on that. And I want to emphasize this. This is where the institutional mediation and arbitration is very helpful. And I think people should be encouraged to have the proper clauses in place, in their contracts when they're entering into the contracts. And deal mediation is another thing that I would just like to emphasize here for the consideration of all those who are listening to us. Okay, thank you.
Wonderful. So let's get to the questions. We have quite a few of them here. I guess I'll pick one. Any mechanism ADR community invented for swift execution of for award and settlement agreements? Any one of you who want to pick up the question?
See, there is no mechanism, but I would like to say one thing. Okay, when you are reaching an agreement, a settlement agreement through the mediation process, the mediator ensures that the agreement is tested. Okay, tested on whether on the specificity of it, on whether there are measurable terms that are incorporated in that, whether it is something that is achievable by both parties, how realistic is that agreement, and what is the time frame within which that agreement performs. And because parties are reaching the agreement voluntarily, okay, because it's their agreement, it is not something that is imposed on them. So unlike an arbitral award, where it is an adversarial process where an arbitrator decides who's right and who's wrong and who should do what, in a mediation, it doesn't happen that way. So the enforcement provision itself is, in my opinion, it is redundant. It's only, it can be effective or it can be used only where one of the parties, even after going through the whole process, reaching an agreement, rescinds from that or reneges on whatever they have agreed to. It's only there that that aspect arises. But a good mediation would be one where both parties have reached an agreement after understanding all the pros and cons, agreeing that this is the best way that they have come to resolve the dispute. So once they do that, the question of enforcement or execution may not arise at all. But to answer the question, the only thing that is available today is we have the Arbitration Conciliation Act, where it is treated as an arbitral award on agreed terms. So you can go to the regular court to execute the award instead of going through the process of proving the agreement and asking for the whatever reliefs that you want to. The other option, once the Mediation Act comes into force, the conciliation goes, because this distinction between mediation and conciliation will be totally obliterated, because the Mediation Act treats conciliation also as mediation. And there are a whole lot of amendments to different statutes wherever conciliation is referred to. So there, that is treated, the settlement agreement is treated as a decree of the court. So it can be directly executed. So that's the only mechanism that is available for the execution.
So my take on this is, I think as far as mediation is concerned, I agree with my friend. I think for arbitrations, it is really, really absolutely necessary for both the bar and the bench to stick up to higher standards. And I'm speaking for the bar also, not just the bench. There's no point putting the blame on the bench all the time. We are also part of the problem as lawyers. I think it is very critical for us to become a little more professional in our outlook when it comes to enforcement. Meaning, we should, I think, start at least big high courts, major high courts where award challenges and enforcement petitions are filed, need to start having rules framed in the high court on timelines within which, pleadings and everything should be completed, and timelines that 80 to 90% of the work should be done in written form. For instance, if you have to argue why the award is to be enforced or why the award is to be challenged, the practice direction on the High Court must specifically say that parties must file a pre-hearing written submission and stick to it in a timeline. And the bench would have read that written submission and come, and the focus on the oral hearing is narrow and limited, rather than arguing it for 10 days in court, which happens a lot nowadays in big awards. I think that is a real critical component. We need to have practice directions or rules framed at the high court levels. Because there's no point looking at an amendment to the Arbitration Act or anything, because the parliament is never going to say that you complete enforcement within 3 months or 4 months. We have seen that on the NCLT side for IBCs. We have seen statute prescribes a timeline, nobody follows it. Commercial Courts Act prescribes a timeline in the statute, nobody follows it. I think the high court level practice directions are what I would say are key elements in ensuring a speedier enforcement and execution of the award.
Just what I would like to add here is also, I would like to emphasize the importance of training for arbitrators. I may have served as a judge for 15 or 20 years, but that does not necessarily make me a good arbitrator. because the difference between a litigation proceeding and an arbitration proceeding is very distinct, because there is a lot of party autonomy that is involved in an arbitration proceeding. It is less informal. It is not as procedure driven as a litigation proceeding. So therefore, the training part of it becomes very critical. And therefore, we are in IAMC, we are very keen that we are conducting arbitration training programs, so that arbitrators who are trained in the process of arbitration act as arbitrators.
Wonderful. Yeah, thank you. There are a couple of other questions. So one question, of course, is on the AI, how it can help in this, right? So what changes brought by AI in this space? So any thoughts there?
So my take on this is simple. I would say that AI is just another tool. I don't think anybody should be under the misapprehension that you're going to have AI systems become mediators and arbitrators. I think that's far, far away. What we are really looking at is, people have already started doing it. When, say, a statement of claim comes, and you're sitting as an arbitrator and a statement of claim comes, you've got AI tools now. You can feed that document in and summarize. So you've got a 60-page statement of claim. You might get a summary. Obviously, the arbitrator would be a fool to simply stick by that summary, because it's only a tool. It's not going to get it right all the time. But that initial input that you want to get, your life is made a little easier. You've got AI systems now which are able to transcribe proceedings. Rather than a stenographer who tends to be a little slow, you can have the entire proceeding transcribed with the assistance of AI. So with that, I believe you can use artificial intelligence as a tool to make things more efficient. But beyond that, I don't see how artificial intelligence is going to, fundamentally turn the procedure in a different way.
Right. Thank you. So one more question on, I guess we are almost out at the time, but let's take one question more. How effective is arbitration in resolving cross-border intellectual property disputes when considering differences in IP laws of different countries?
It's a superb question. I'll tell you a good example if you're able to take the time to read it. There are some ICC awards on standard essential patent disputes. Some of them are available publicly also. You are correct that there are differences in IP laws, but when the parties are consenting to arbitrate and you have chosen a substantive law of contract, I think it brings down the level of confusion significantly. The only point where this difference in law is going to make a hell of a lot of a difference is if you're arbitrating on the validity of your IP. Let's say in the course of your IP dispute, I'm just giving an example hypothetically. Let us say it's a patent license agreement. The plaintiff has given a license to the defendant, or the claimant has given it to the respondent, and the respondent has not paid, so an issue arises. Let's say the respondent's defense to the claim is, oh, by the way, this is a patent license agreement. Your patent itself is invalid, which means it's a void contract. The foundation of your contract is void. I don't have to pay you any money. Okay. And imagine this was a multi-jurisdictional contract. So two global enterprises enter into a contract of a patent license for 10 different jurisdictions. And I don't know, because my friend is here, let's assume it's a software or a high-tech related contract, which means you've got issues on software patentability. Let's say that respondent's defense is your patents are all not patentable. Now, the reality is 10 different jurisdictions have 10 different statements on law on what is patentable as far as computer implemented algorithms or computer implemented inventions are concerned. Then which law will be applied? Because you've licensed patents across 10 jurisdictions. Ideally, the court or the arbitrator will have to decide each bunch under each separate law, theoretically speaking. But so far, usually IP validity is never arbitrated. As a matter of practice, it's usually not arbitrated. So because of that, this very thorny question has not been answered, at least to my knowledge. But other than that, if you're looking at typical licensing issues or infringement issues, I don't think the substantive laws being different make too much of a difference.
Fair point. Yeah, no, I think that's
I think the challenge comes only with the execution part.
That will be
Get the award. So perhaps the preferable route would be to go for mediation,
right.
because that would lead to a settlement agreement that would be acceptable to all.
Yes. Yeah. So I guess last question: where to look for mediator? Jawad sir, maybe you want to give your visiting card?
You can always come to IAMC. We will appoint the mediator for you. We suggest the mediators.
Yeah.
We have a panel of expert mediators. So
Right.
it should not be a problem. So you can check our website and reach out to us. We'll be glad to help. That's why we are here, to serve you.
Yeah. So now I think wonderful session. I think we are beyond our stipulated time. So I would like to really thank you, Jawad sir, and others for your valuable time and insights. I think definitely going by the comments and my personal observation, I think it was great insight. As you rightly mentioned, a lot of these end up in litigation, and mediation and arbitration is a great alternative that we all should explore. So wonderful insights covering almost all spectrum of arbitration and mediation, specifically with respect to IP. So thank you again, and would love to hear you more, maybe in some future platforms. But again, thanks a lot from my side as well as from SOCHAM and the participants. It was really an engaging session. Thank you.
Thank you. Thank you.
Thank you, Jawad sir and Adarsh sir, for insightful presentation, and thank you all attendees for joining the today's session.
Thank you.
Thank you again. We'll reach out to you separately, but
Yeah.
wonderful.
Thanks so much.
Thank you. Bye. All right. Thanks, Parul and Kirti. I'll sign off as well.
Yeah, thank you, sir. Thank you, sir.